Thank you so much for clicking this video. This is Batok with Ola. My name is Mujola Oluwa, and today I want to discuss Shande and the state. Shande and the state. It's a 2005 Supreme Court decision, although the subject matter, first took place in 1997. So I went on trial and then on appeal to the Court of Appeal, then appeal to the Supreme Court, and a decision was made, a landmark decision if you will have it, in 2005. So what happened in this case? It's a criminal matter, a murder matter. So a man, a civil servant, let's call him Mr. Shande, had a wife and two children, and they lived together in Benue State, Nigeria. So because of his work, the man used to live at a different location most of the time. Then he would come back to where they were. Let's say maybe someone was working in a state or was on outposting, and then he would come back to his family, something of the sort. So he had a girlfriend, a lover, a paramour. So who is the subject of the matter? So the wife knew, and people also knew that he had this girlfriend, but apparently the wife had not really got with the program. So what happened was that on this particular day when the incidents happened, that girlfriend visited him at home, and the man had when the man arrived, he had told his family that, oh, the girlfriend will be coming and she'll be joining him on the farm the next day for planting of granules. So when she came, they were eating. The man was eating with his wife and their compound and all of that. So when she came, he got up from his wife's table and went to his father. His father also lived in the compound, apparently. So he went to his father's table to eat, where the girlfriend joined him. They offered the girlfriend food. She said no because she had brought her own food, so she ate it. So after some time, like a few hours, the girlfriend said that she was feeling cold and wanted to sleep. So the man instructed his wife to prepare her own bed for the girlfriend. Apparently they had been sleeping in the same hut together on the times when the girlfriend would come and visit the man at home. So it was one hut. The man had just one hut in the compound. So the wife prepared her own bed, the lady slept in it, and then the wife slept in her kid's bed with her two kids. Then in the middle of the night, there was commotion, and when everyone came out, the girlfriend was ablaze, set on fire. And then they rushed her to the hospital, but it was too late. She died, and the wife was charged with murder. The husband and three other people testified against her. So she confessed that she indeed poured kerosene on the girlfriend and set her ablaze, and then she was sentenced to death. And she appealed to the Court of Appeal. She lost. Then she went to the Supreme Court. At the Supreme Court, the contention of our lawyers, of course, was the defense of provocation, that it should have availed her at the trial court, And at the trial court, the judge had said that provocation could not avail her because she already knew about the girlfriend. It wasn't the first time, and it wasn't as if when they went into the hut to sleep, the girlfriend did anything or said anything that would have provoked her at that time. Because by Section 22 of the Penal Code, which covers the northern Nigeria, where Benue State is, provocation, sudden and grave provocation, is a defense to a charge of culpable homicide. So a person would not be sentenced to death for culpable homicide if they could prove sudden and grave provocation. So the court held that there was no provocation. So, and then at the Supreme Court decided to go the way of cumulative provocation. So the Supreme Court decided to look at the entirety of the situation, that this is someone that had turned her husband's affection from her and her children. The husband was no longer catering to the home front because of her, and then she had to take care of her, house her in her own bed, sleep with her in the same room with her children. So the court considered cumulative provocation, that all these things could have piled up and built such provocation within her that would have resulted in what she did, setting the woman ablaze. So the court held that provocation, that the lower court should have considered provocation, the defense of provocation, in her favor. Also, she was contending that a confessional statement was involuntary, that she did not make it. And the Supreme Court was able to find that in the trial court's record, there was nothing to show that she was shown the statement in court and she identified it as to have been of her own making. So that is also something. If you're a prosecutor, make sure that this process is not skipped or not recorded. So the defendant must identify the statement and admit to have written it voluntarily, so that the evidential weight, attached to that statement will not be watered down. So this was the decision. The Supreme Court decided that the confessional statement was involuntary, and that the lower court should have considered provocation in her favor. So the court held that the case should have been sent back for retrial to the trial court, but the court decided that it could amount to injustice, in 2005, deciding to send back a 1997 case for retrial. So the court just went ahead and set her free, discharged and acquitted. So that's the decision in Shande and the state. It's a landmark decision explaining the defense of provocation and shining some light on the importance of voluntariness, in the making and the tendering of confessional statements, in criminal litigation in Nigeria. So that's the case in Shande and the state. If you have any questions about this case, or if you want to continue the conversation, leave those things in the comment section for me. Don't forget to check the description box. There are gems for you there, and don't forget to subscribe to Battle with Ola. I will see you in my very next video. Shande became a free woman in 2005. To-dos.